Good day and welcome to the Free Market Foundation. My name is David Ansara. Welcome to this special media briefing brought to you by the author of our latest paper, which is our head of policy, Martin van Staden, who joins us today. Thank you, Martin, for being with us. And this paper forms part of the Liberty First series of policy recommendations that we have put together. You can access that on our website, freemarketfoundation.com, as well as our Liberty First series. It is called Constitutional Land Reform Alternatives to Confiscation and Land Retribution. So, Martin, thank you very much for putting together this paper. And I think it's an important rejoinder to expropriation without compensation. I think many people, when we're engaged in our advocacy work in defense of private property rights, they say to us, well, this is really the only way to deal with the injustices of the past. We're merely making explicit what is implicit in the Constitution by driving this expropriation without compensation agenda. We reject that argument. We say that actually there is an alternative, which is strengthening tenure security, strengthening private property rights. We do concede that there should be some mechanism for expropriation. This is akin with liberal democracies around the world. I'll let you kind of explain the reasoning there. But yeah, so this forms part of our Liberty First series, which is a series of policy proposals and recommendations from the Free Market Foundation. And I'd encourage you to go to check out some of our reports from earlier in the year as well. We have a comprehensive set of proposals. So this forms part of the legal system and property rights section of that policy agenda. So Martin, let's start off with just discussing the constitutional protections for private property rights. Section 25 specifically, what does the Constitution say about property rights and also land reform? If you could give us an overview, that would be great.
Yeah, thanks, David. South Africa has a very special property rights provision in that it's very comprehensive. A lot of people, when they think about private property rights kind of enshrined in law, they think of, well, the United States and their constitutional protections for property. But in the US, it's almost a passing reference to property rights, where they say that no one will be deprived of their property without due process of law and the payment of just compensation. And that's it in the US Constitution. But our section 25, very comprehensive, 9 subsections. And effectively, these come in there's 3 dimensions to it. So section 25, 1 through 4, is about protecting private property rights. This is the foundation, the basis of what people think about when they think about private property rights. This kind of is derived from that constitutionalist recognition that in a free society, people's rights are protected. So this is the basis of section 25. It's 1 through 4. It says no one may be deprived of property except in terms of a law of general application. And it goes into how expropriation works. Now, as you alluded to, expropriation is normal. A lot of the opponents of what we say and people who support the current Expropriation Act will say that, oh, we're being fearmongers and every country has expropriation, and then why are we saying there should be no expropriation? That's false. There is expropriation in every society on the planet. There is not one exception. But the way that these countries, especially the free ones and the prosperous ones, approach expropriation is very different from what we see in the Expropriation Act and what we see in the Constitution. The Constitution says that yes, your property may be expropriated, subject to the payment of an amount of compensation, taking into account the various factors. So that's sections 25, 1 through 4 that provide for the protection of private property rights. Then there's section 25, 5, which provides that South Africa has this past of kind of denying to people the ability to own property, and therefore the government does have an obligation to expand ownership, the expansion of ownership. South Africa, as a country that comes from a time of deprivation, must become a property-owning society. South Africans, civilians, ordinary citizens must become property-owning. So it says that the government must adopt measures that foster conditions that enable equitable access to land. And now political actors have taken these very innocuous, very normal words and twisted that to mean redistribution. They say that that means the government may look over the plentiful land area of South Africa, look over its private property, and pick and choose. I'm going to take your property and give it to you, or I'm going to, and more likely in practice, I'm going to take your property and keep it in state ownership. So Section 25.5 has been misconstrued by anti-property rights forces in South Africa to mean redistribution of land and the nationalization of land. But any normal, sensible person who reads this provision understands and can see immediately that that is not what it means. It's about fostering conditions that enable people to become landowners. So that's the second dimension of Section 25, the expansion of ownership. And then very importantly is the delivery of justice. That's Section 25 sub 6 to sub 9. And this effectively reinforces the basis that I just referred to. It says in Section 25 sub 6 that people who, due to past racially discriminatory laws, were denied security of property must be secured in that property. So it reaffirms the centrality of security of private property. It doesn't say that the government must ride roughshod over people's property rights to enable land reform. No, it says the opposite. It says government must strengthen property rights, specifically in recognition of past injustice. So specifically, sub 6 would be referring to township areas where people are tenants rather than owners of their property. The government must go in and make sure that they are owners. And it also applies to rural land and so on, where you have a lot of tenure insecurity. And then the other provision in this kind of portion of Section 25, crucially, is restitution. It makes explicit provision for restitution for those people who were dispossessed of their property after the adoption of the 1913 Natives Land Act. This is what a lot of people have in mind in the discourse around land reform, the very high temperature discourse around land reform. When we say we must protect private property rights, then our opponents would say, no, but how can you say that ill-begotten property should not be returned to its real owners? And that is, of course, not what we're saying. The protection of property rights includes the principle of restitution. And our common law, our Roman Dutch common law, our English common law, have recognized this for millennia. It is a sacrosanct legal principle that if someone has gotten property illegitimately, that property must be returned to the real owner. No one is debating that principle. I have not seen any notable South African kind of formation that is pro-property saying that we must do away with the principle of restitution. And the Constitution recognizes how crucially important it is that those who can prove, and our law makes ample provision for this in the 1994 Restitution of Land Rights Act, those who can prove that they were dispossessed, and you can prove it. There is this idea that in the 1990s, the outgoing National Party was shredding evidence in the deeds registry's office and so on, kind of covering up the dispossession of land. No, that never happened. The records are all there. The previous regime meticulously documented when it took property and utilized it for other reasons. So the evidence is there, and tens of thousands. I believe the latest number that I heard is about 86 or so thousand claimants. And these individuals all represent communities and families, have applied through the land restitution process, and the vast majority of those have succeeded. They have won in the land claims court. So this is a process that has been going on, and it has been working to the degree that the government has taken it seriously and funded the restitution process. But yeah, let me leave it there. That is the last dimension of Section 25 of the Constitution, which provides for a recognition of past injustice and the need for the restoration of a just state of affairs.
Right, Martin. So the Expropriation Act was signed into law earlier this year, much to the dismay of civil society organizations like ours, who have been arguing that the act is fundamentally unconstitutional. Bear in mind that the ANC government attempted to amend the constitution back in 2021. It failed to do so because it didn't get the sufficient parliamentary majority to make that amendment to Section 25. So already it is acknowledging that there is a constitutional barrier there, that the Constitution prohibits that kind of conduct. So maybe you want to unpack that, because what are the specific constitutional concerns that we at the FMF have with this piece of legislation?
Yeah, so let me start where you ended off. So the ANC in 2017, in December of 2017, adopted a resolution at its leadership conference that it would want to amend Section 25 of the Constitution to enable expropriation without compensation. Because, why? Well, the government wants to the ANC wants to expropriate property without compensation. So it recognized that the Constitution prohibits the expropriation of property without compensation. Now, before this time, and a lot of people kind of viewing the discourse now will not believe me when I say this, but please do believe me and fact check me. Before 2018, let's say, there was no discourse in our country, no kind of jurisprudence from our courts, certainly not amongst legal academics, of a notion of expropriation for nil compensation. There was no such thing. Suddenly, it was always expropriation without compensation, kind of derived from Robert Mugabe's regime and that idea of taking property without paying people compensation. That is, to the degree that there was a discourse, that is how it was framed. Suddenly, now with the threat to the Constitution, when Parliament in February of 2018 adopted a resolution saying that they will appoint a committee, an ad hoc committee, to investigate how to enable this thing, what they now called expropriation of property for no compensation. And we very quickly found out where this came from. This was a group of legal academics who still remain active today, and legal advisors who basically asked themselves, geez, so the ANC wants to do something to the Constitution that doesn't really seem right. Expropriation without compensation, it might sound coherent, but any lawyer will tell you that this is a necessarily incoherent concept, because expropriation, the word itself, implies compensation. It's a lawful taking of property alongside the payment of compensation. There is no such thing anywhere on the planet as expropriation without compensation. That term refers to confiscation, kind of property just being stolen by the state. That is what it is. It is not expropriation. But these legal academics basically asked, how do we, let's say, let me steelman their position and give them the benefit of the doubt. How do we save the Constitution and kind of legal coherence from what the ANC and their majority in Parliament wants to do? And they came up with this idea of no compensation. The idea is the law will enable the government to expropriate property with compensation. There is compensation, but that compensation might be an amount of nil, 0 rand, 0.00 rand. And that is the compensation that, in terms of the Constitution, is paid upon expropriation. Now, with all due respect to these thinkers, maybe they wanted to save the Constitution, but this is not the way to go about it. This is obviously what again in law is known as vrouws legis. You are defrauding the law. You are effectively recognizing that there is an impediment to what you want to do, a legal constitutional impediment. You are not allowed to do the thing, and now you are finding ways of kind of sidestepping that requirement through the clever usage of language. It is like if you evade taxes by disguising income as a donation. It is exactly the same principle. Vrouws legis, you are simulating a falsehood, a facade over the reality. And what is the reality? Confiscation. So Section 13(3) of the new Expropriation Act of 2024 provides that the government may when it deems it in the public interest, and what those circumstances are will always just be case dependent. There's no fixed closed list of when the government may confiscate property. But when the government deems it in the public interest, it may confiscate property or it may expropriate property for an amount of no compensation. So this is necessarily unconstitutional. Our constitution is very clear in section 25, 2 and 3 that when there is expropriation, there must be a payment of an amount of compensation. You cannot pay nil. It is impossible. A payment necessarily means that there has been a value transfer, a transfer of monetary value from one person to another. If 0 rand goes from one person to another, nothing has been transferred. There is no transfer of value, so it cannot be paid. It is not an amount. 0 rand or 0 or nil is the absence of an amount. That is what it means in law. That is what it means in reality. And our constitution is not a constitution made for actuaries and accountants. It is a constitution made for society. It has been emphasized by our courts and by legal thinkers that it is a constitution of plain meaning. So you cannot look at words like amount and payment and say, well, if you in the highfalutin kind of technical language of accountancy, you might have something like 0 rand on a spreadsheet. It does not matter because this is not in a constitution for accountants. So 0 in this context is the absence of an amount. So on 2 scores already it cannot qualify. But perhaps the most important one is compensation. Compensation is a well-trodden, well-known term in law. It means when a harm has occurred, a damage, an injury, an inconvenience, and someone has to be compensated, it means that the inconvenience or the harm or the damage is undone. The person is placed in the position that they would otherwise have been had the harm, the inconvenience, or the damage not occurred. That is what compensation means. If something harms you, you're compensated and the harm is undone. So when you talk about nil compensation, that is, again, a contradiction in terms, because if your property, even if it's a relatively low value piece of property, if it has been taken for nil, you have per definition not been compensated. It is an illogical kind of step to try and argue that there has been any form of compensation. I know the previous or maybe current deputy minister of something, I think trade and industry, who was Jeremy Cronin, he once remarked at a land summit that shaking someone's hand and saying thank you for your property suffices as compensation. Spoken like a true communist, of course. That is not how it works. Compensation must be something that is substantive. Again, that's another thing that our constitution is known for, not just here, but around the world. It is a constitution of substance over form. To say that we have deemed you to be compensated because we shook your hand or gave you 0 rand, that is a formalistic trick. There is no substance to it. Substantive compensation means, and this is the important part, you are paid the market value. And let me emphasize that, the market value at least of your property. Now, the market value of your property might be very low, and that kind of is toughies, but it must be the market value of your property. Otherwise, you have not been compensated. And lots of people want to point to the words just and equitable in the Constitution to say that it's not market value compensation. It has to be just and equitable compensation. That, again, is nonsense. The word justice means to give someone what they are due. That is what justice means. Equitable means to not act unfairly towards someone. So just and equitable compensation, again, is market value compensation. So the Expropriation Act is unconstitutional, and we believe it is necessarily unconstitutional. There is no intricate argument to be made for it. It is on its face basically unconstitutional in the way that every first-year law student is taught a law is unconstitutional. There's a constitutional requirement which is clearly stated, and this act one-to-one goes against that. It enables the taking of property without compensation when the Constitution requires it. And the Free Market Foundation is at a relatively advanced stage of a process of getting involved in litigation that we hope will see the Expropriation Act declared unconstitutional on that basis. But the other thing that I mentioned in the paper, which is notable, and this is just to kind of speak to the discourse around the act, is that it is not a land reform law. The discourse around the Expropriation Act has been so tied up in the discourse around land reform, and this is a problem, because it muddies the water and it makes it very difficult for people to communicate. There is no land reform provisions in the Expropriation Act. The act has been adopted and it can sit on the statute books without any land being used for land reform in terms of it forever, and it would not be breaking the law. So this is not a land reform statute. It is on its face an expropriation law statute, which is all about empowering the government to take property for kind of a legitimate government purpose. But it is not unlike the Restitution of Land Rights Act, which is a land reform law. It is not a land reform law, and we should kind of be very conscious of dividing the discourse up. We can have the conversation about the importance and the necessity of land reform, but that is a separate question from whether the Expropriation Act meets constitutional muster, which it assuredly does not, and it in many ways returns us to a kind of point in South Africa's history where people weren't secure in their knowledge of their ownership because the government had empowered itself so much to take property from blameless ordinary South Africans who have not done any wrong. That's maybe just a last point on this, is that expropriation law is not criminal law, and it is not the law of delict. That means, so in criminal law and the law of delict, there is a wrongdoer. Someone has done something wrong, and that has to be set right through the application of criminal law, and you have to prove guilt beyond a reasonable doubt. Or in the law of delict, a civil wrong, you have to sue them, take them to court, and on a balance of probabilities also prove that that person did something wrong and that they are now going to have to set that right somehow. Expropriation law is not part of that. But if you look at how the Expropriation Act has been sold by politicians in this country and by their supporters, it is almost kind of rhetorically included in criminal law. This is the act that we're going to use to punish people for sitting on land, for having land that has been ill-begotten. But that is not how you do it. If you, as a South African, believe that land there has been stolen, those are fighting words. You have effectively accused the owner of that land of a crime, and there is a way to deal with that. You must lay a charge of dispossession of property. There's various ways you can do that at a police station, and that person must be prosecuted. And then it must be proven beyond a reasonable doubt that they have in fact stolen that land. But you cannot try and use an expropriation law measure. An expropriation law is all about regulating how the government may acquire property, and then for a legitimate purpose, and then use that for a legitimate purpose. That is not criminal law. That is not the law of delict. So an owner who is being expropriated cannot be treated as a guilty party in a criminal or delictual claim. They are, and always are, under expropriation law, innocent victims whose property is needed by the government. And that must be recognized. And that means, in terms of expropriation law that you find in all the free and prosperous societies of the world, there must be a high degree of respect for the owner. The owner did nothing wrong, so you respect them, and you are deferential towards them. You must be helping them as the government to kind of comply with what needs to happen. And of course, you must pay them market-based compensation. You cannot treat them like pariahs. You can only do that if you go through the due process requirements stated in criminal law and in the law of delict. So that's a long story, but that is effectively the many facets of the unconstitutionality of the Expropriation Act.
Yeah, Martin, I think that's a very good overview of some of the constitutional problems, and that is exactly what is animating us as the Free Market Foundation. It's not only push back against the Expropriation Act in our advocacy, but also in the courts as well. There are multiple arenas with which we are challenging this. And we invite those members of the public who are interested in supporting our cause to please support us financially or otherwise. So I just have one more question before we hand over to questions from the audience. So if there are, in particular, journalists who are in the audience who would like to address a question to Martin, please get your question ready and also identify yourself and your publication, but also members of the public who are tuning in are welcome to ask questions as well. And I see a couple coming through in the chat. So you've outlined the constitutional provisions and the protections for private property rights. You've explained why the Expropriation Act is unconstitutional. But as I mentioned in my introduction, people who criticize our work often say, well, what are your alternatives? But here we have some alternatives. Could you give us some highlights of what you've proposed in your paper, Martin?
Yeah, absolutely. I think the first thing and the most pressing issue is that the Expropriation Act itself must be done away with and replaced by what we have termed an Expropriation Control Act. Effectively, this will normalize expropriation law in South Africa and bring it in line with the open and democratic societies of the world, where expropriation law is an institutional arrangement that protects owners from abuse by the state. That is what expropriation law is. Our Expropriation Act flips that completely on its head, as I've explained, and we believe an Expropriation Control Act, which controls the expropriation power as the Constitution requires, is necessary as an immediate course of action. There should be no undue delay in government adopting this act with some haste. And it will, as I've just explained, just normalize what I've said. The owner must be treated with deference and respect. There must be a prohibition on property confiscation. That means that there must always be market value compensation as a minimum. And that various other bits and bobs, the current Expropriation Act makes it very difficult to comply with a lot of the requirements, and we think that those compliance burdens must be made easier, and specifically that the state must assist the owner in complying at every step of the way, rather than making it their responsibility. So that's the first and the key intervention that needs to happen. There are a few others in this area of protecting property rights, this I mentioned, and that is that the land court that has been recently established, the Land Court Act, must be modified to bring it kind of back in line with the rules of due process that are applicable in all South Africa's other courts. For some reason, this court is being set up with laxer requirements, specifically in the law of evidence, which allows hearsay, which is a big no-no in any just system of law. You cannot allow hearsay this easily. So there's various modifications that need to be made to the Land Court Act to bring that in line with certainly international best practice. But then more on the kind of substantive side of pursuing an agenda of land reform. The Section 25(5) aspect, where I mentioned it's to do with the expansion of ownership, kind of the key thing there that needs to happen is exactly what the text provides. The government has to foster the conditions that enable citizens to gain equitable access to land. What does that mean? You have to foster the conditions, you have to create an enabling environment for ownership. That means that the massive amounts of red tape that currently pervade South Africa across all spheres of government, municipal, specifically municipal, but provincial and national government, all the red tape and bureaucracy that is associated not just with buying and selling property, but also with transferring property. People might hear about this and think, yeah, but that's normal, and it has been normalized. But South Africa's socio-economy doesn't allow us to be so blasé about it. A pauper, a poor person, kind of wanting to sell or transfer property, cannot ever hope to afford the kinds of compliance costs that are associated with this. Just think of the example of if you have to transfer your property, you have to make sure that the building plans for your property are up to date. If they aren't up to date, you have to commission an architect to redraw your building plans. That could cost something like 30 or 40 or 50,000 rand. That to some that might sound like a small amount of money, and maybe you'll find a pro bono architect somewhere. But on the whole, people cannot afford that. And then there are various compliance or fees and compliance costs associated with engaging the deeds office, not even to speak of the backlog that is now synonymous with every deeds office in the country, where you get put in a list and maybe sometime in the next 5 years you can get something done at the deeds office. That is not fostering conditions that enable South Africans to gain equitable access to land. So a lot of these requirements and these kind of I want to call them Western kind of formalisms that have kind of ingrained themselves in South Africa need to be done away with. And we're going to have to accept that that might come with some costs, of course. But the Constitution is very clear that the government must foster these conditions. And unless the government is going to subsidize complying with all these various things, they need to rather just get rid of them and enable South Africa to become a property-owning society. But most importantly here is the taxes. We at the FMF like talking about tax cuts, and that fits in perfectly well here as well. Capital gains taxes are levied on second residences, and then you might think, okay, well, no one needs more than one house, but there is a reality in South Africa that if you own a house in the Eastern Cape and you come to Johannesburg for seeking job opportunities. I mean, your house you built in the Eastern Cape with your own bare hands 2 decades ago, or your grandfather built it 2 decades ago, and you now purchase a house in, say, in Alexandra in Sandton, and now you have to pay capital gains taxes. You are a poor person trying to find work, but now you are being punished because the state wants to profit off of your quest to become a property owner. But then over and above capital gains taxes, you have property rates. We're big federalists. We do think that municipalities should have independent means of acquiring revenue. But the example that comes to mind here is that imagine you are a family who has proven to the land claims court that your tract of land in a rural area was dispossessed in 1925, and you have now won the claim. So now you are entitled to receive this tract of land, this big multiple kind of hectare property. And you're excited about that. You're returning to the land of your ancestors. And now you have to go speak to a conveyancer about the process. And the first thing the conveyancer is going to ask you is, this is great, congratulations, you've won your land claim. Can you afford the property taxes? And the answer is going to be no, because no person kind of just goes into farming on day one being able to afford the huge municipal property taxes that will be levied on those properties. It is a non-starter. So what will you do? You're going to forego the land and you're going to take financial compensation instead. And about 88 to 90% of restitution beneficiaries who have succeeded in proving their claims choose financial compensation. There's other reasons for that. People prefer to live in the cities. Very few people, extremely few people, want to be farmers in the rural areas. But of those who would like the land back, it is beyond any doubt that the financial burden that the state contrives, it's not a natural financial burden, but the financial burden that the state contrives that you will have to comply with if you become a rural property owner is massive. So we would say that the government, in fostering conditions to enable equitable access to land, must cap municipal property rates to a maximum that applies across the board, and that the lower that is, the better. Yes, the municipalities are going to cry some tears, and we'll cry with them for a while, but this is a bullet that needs to be bitten if we want people to become private property owners in South Africa. Another thing that the government can do quite easily is repeal any remaining restrictions on the subdivision of agricultural land. We want farmers to be able to say, I'm going to cut off 5% of my land and sell that at an affordable price to someone probably from the community, to a worker that has been associated, for example, with that farmer for many years. This is how you foster conditions to enable equitable access to land. But no, currently under our law, you have to get permission from the Minister of Agriculture. You have to go through a massive bureaucratic process to subdivide your land. I know there are various good reasons for the restrictions on the subdivision of land, but there are also good reasons to repeal those restrictions and enable more affordable plots of land to be cut off from farming units and other rural property, and sold for a more affordable price. Then a last note on fostering conditions to enable equitable access to land. The Institute of Race Relations has very long been an advocate of housing vouchers. We think that there might be some significant financial burdens to the taxpayer that could be associated with this, so it does need some careful study, but it is also a far more equitable, far more reasonable thing that the government can consider and potentially implement to foster conditions that enable equitable access to land. So provide low income earners with a periodic voucher that they can invest either in purchasing property, in building property, residential property, or even in renting property where they deem desirable. Currently, people are being put in these RDP state housing complexes. People don't necessarily want to live there. They want to go and rent in town close to where they work. And that's a far better alternative than forcing them to build a shack. So a housing voucher is a good way to do this. And then on that last dimension, the delivery of justice, this is where kind of things maybe get a little bit contentious for some people, but the Free Market Foundation has had its Kaya Lam land reform project since the year 2010. We're very proud that more or less about 20,000 title deeds have been facilitated by the Kaya Lam project since then, and that represents not just 20,000 people, but these are all families. These are potentially hundreds of thousands, if not already millions of people are benefiting from having a title deed to their municipal urban land. We focus specifically on urban land in former apartheid peripheral townships. I think some RDP kind of housing is also mixed in there somewhere. But the idea is that if you are lawfully present in a house, or lawfully present specifically in a state house or a house that was built on municipal land, then in fact you should be the owner of that. Why? Because the state is not a landlord. The state is not a commercial institution, and we shouldn't create circumstances where the state is our landlord. It is a institution that must guarantee law and order in society, not an institution that we must pay to live on its property for. That is just a perverse conceptualization of the state. So we believe that there must be titling. People on urban land is the most important one. If they live on a house on state land, they must get a title deed, full and unambiguous ownership of that land. This speaks to that securing tenure for people who have insecure tenure. That section 25(6) of the Constitution doesn't recommend, it requires it. So these people are by constitutional right entitled to that ownership. The other thing is that the state owns a hell of a lot of property. And no one really knows exactly how much, because state departments themselves do not really know what it is that they have. So we are recommending a comprehensive audit of state-owned fixed property across all spheres of government, municipal, provincial, and national, and independent organs of state, like universities and SOEs. These should all be audited, and every grain of sand that they own must be accounted for in an asset register, with a view to offloading this property and giving it to deserving South Africans in title, in ownership, not leasing it out. Our government enjoys getting property and leasing it out to people, and then when a comrade comes along and says now he wants the property, then the current tenant is kind of thrown off unceremoniously. That is not what we want. We want ownership. The Constitution says South Africa must become a property owning society, not tenants of the state. So we want this audit to occur, and then anything that is not tied to a kind of core state function must be gotten rid of. It must be gotten off the state asset register and transferred in full ownership to deserving South Africans. Then, of course, we've already mentioned it, but restitution. South Africa has the 1994 Restitution of Land Rights Act, a very good piece of legislation that says that if you can prove that you or your ancestors in title were dispossessed of land, in terms of one of the various kind of apartheid era pieces of legislation that made this possible, and you can prove it. Again, I must emphasize that the evidence is there. There was no cover-up. This is something that the apartheid government was very proud of, its grand apartheid vision. So the evidence is all there. If you can prove to a court that a piece of land is in fact yours, then you do by right have an entitlement to get that land back, or if you prefer to take financial reparation for that. Now, the key thing to emphasize here, and this is where the discourse gets heated again, the current owner of that property did not dispossess you or your ancestors. That person could have bought the property a year ago from a black South African, for instance, and that highlights the perversion of the current approach to the discourse. A property could have changed ownership across racial barriers dozens of times between the end of apartheid and now politicians and their supporters are saying, well, the person who owns it right now must get zero compensation if their property is taken for the purpose of restitution or some other reason that the state needs it. It cannot work that way. Unless you can somehow show that the current owner is the person whose hands are dirty, who has dirty hands in the eyes of the law, who took that property from you or your ancestors, yes, then their property can be taken without compensation. But that is not expropriation. That is just criminal asset forfeiture, and you have to go to court and prove beyond a reasonable doubt that that has happened. But in all other circumstances, that person who must now part with that property in terms of the imperative of restitution must be paid the market value of that property in recognition of the fact that they did nothing wrong. And if the law doesn't care about people doing or not doing anything wrong, then there's no reason why we should cling to ideas like innocent until proven guilty or due process of law. If we think that, well, if you own property, you should just kind of be okay with it being taken from you for nothing, then we can basically take a sledgehammer to all the pillars of our justice system and become a totalitarian dictatorship. We may as well do that. So no, we don't want to do that. There must be this equitable and just approach. And we think that the restitution process must continue. And it must be strengthened. Currently, it's one of the lowest budgeted items in the annual budget, and it's been that way for decades now. That restitution gets, my goodness, I think the number is something around R1 billion a year. That is ridiculous.
If you contrast that to the entire budget for the Department of Sport, Arts and Culture, that's about 13 billion.
Yes, exactly. Yeah. It's orders of magnitude higher, and yet you don't have politicians shouting about sports or arts and culture. You have politicians shouting about land hunger and the imperative of land reform, yet they don't budget for it. And my suspicion is that this is on purpose, because land reform, as I've said throughout, is it raises the temperature of politics. It's something that gets people's blood flowing, and the longer you can drag this out, the more it benefits politicians. So in my view, the land reform issue could have been solved in kind of the 10 years after apartheid ended. It's not like the restitution of property is rocket science. Far from it. It's something that could have just been done, but no, it was dragged out by the state, and I expect it to be dragged out more if the state continues to benefit, like it has with the Expropriation Act, benefits so much from milking this narrative of hunger for land and so on, when it can just do the thing. Capacitate the restitution process and just get it done. Make sure that justice is delivered, and this cannot be underemphasized. It's something that can be done relatively quickly. And then the last thing I want to highlight is the idea of two things. Firstly, is state property. And communal property. The political class in this country has been very good at making the idea of community property kind of the the state of affairs that existed in South Africa before colonialism, taking that and making it a euphemism for state ownership of property. We do not mind at the Free Market Foundation, as liberals and libertarians and capitalists, we do not mind communal ownership of property. If people want to own property in common, then they must, of course, be allowed to own property in common. And even Western legal systems have accommodated this in the form of sectional titles and so forth. But that is not a problem for us. The problem that we have is that communal tenure in South Africa is interweaved with state ownership. And that's a problem. We believe in private property, and that private property can be communal property. It must be property that's used for the benefit of the community. So we would say that the 2017 Communal Land Tenure Bill, which more or less kind of goes in this direction, which is a good direction, should be refined, and some of its problematic provisions should be removed, and it should explicitly make provision for community ownership of property that is not tied to the state, and that we think would be a good measure. And then the last thing is probably the most contentious one, but this is a bullet that we think people should bite, is that since 1998, the current South African regime has gone about nationalizing water, minerals, and petroleum. Whether you think this is fine or normal is quite irrelevant. The fact is that we live under a hopelessly corrupt and inept government, and I think for the foreseeable future, that is how we will continue to be governed. That such an institution has no business being the trustee or the custodian of these vital resources that put South Africa on the map a century ago. We need to restore natural resources to their private owners, because private ownership will always steward resources, scarce natural resources, in a far more efficient and economically beneficial way for the public, for the whole society, than the state could. So we would say that the National Water Act, the Mineral Resources Development Act, and the brand new Upstream Petroleum Resources Development Act must be repealed and replaced with the common law principle that the landowner owns all property beneath and above their property. That includes water, minerals, and petroleum. And this is how it works in some places around the world. This is how it worked in South Africa in the 1990s, so not that long ago. It's not that revolutionary, but it is necessary if we want to see communities starting to benefit from mining and petroleum resources around them again. And those are the highlights, but I would recommend that people have a look at the report and read it and see the tangible reforms that could be introduced tomorrow to speed up and accelerate substantive land reform while protecting the crucial precondition for prosperity and freedom, which is private property rights.
Thank you very much, Martin. I am just sharing the cover of the report, and also the link has been posted there in the chat. So I'd encourage our viewers to go and check that out. And we've been receiving quite a few questions in the comments, and I want to give priority to members of the media specifically, just because this is a media briefing. So I see Radio Nieuwe saying that seeing that the NDR, which is the National Democratic Revolution, is alive and kicking, can the government be legally forced to do anything that seems to be moving them away from their own goals? A very interesting question there. Martin, do you have any thoughts?
It's a tough one. Very, very good question, but we wouldn't be litigating if we didn't think that the law could be used to move the government away from, perhaps not from their ultimate goals. Our courts are very hesitant about imposing public policy on the state, but certainly the way they go about it. So our litigation, the litigation that we're joining, is about the Expropriation Act. And this is a way in which the government is trying to achieve their ultimate goal under the NDR, which of course is complete state ownership of everything, and that us mere plebs must be kind of lessees who only operate by the grace of our local politicians, and that's unacceptable. But no, that's not a battle you're going to win in the courts. That is a battle you're going to have to win in the hearts and minds of ordinary South Africans. But there are ways that the law can be used to throw a spanner in the works of the government's agenda, and we would encourage people to get involved in litigation. And certainly, even if the Expropriation Act becomes law and it's not found unconstitutional, remember, you can always still challenge expropriations. And we would encourage people to do that and throw as much sand in the gears to make that process as laborious for the government and as expensive for the government as humanly possible. And maybe then it will realize that it is barking up the wrong tree now and needs to change tact.
All right, Martin, thanks very much. And we had a rather critical comment in the beginning of the stream from End Z Meat, which I'm showing on the screen here now. He's saying, are we all clear we're talking about the property, land, and assets that the whites accumulated during colonialism and apartheid crimes against humanity? I think for those who were listening to Martin's remarks, he emphasized the importance of restitution for properties that have been seized unlawfully by the state, and that there's a legitimate claim against the state by those victims of those abuses. But that restitution process should not be confused with what is being proposed here with the Expropriation Act. Well, not even proposed, it's on the statute books, which is essentially confiscatory. Martin, do you want to elaborate on that?
Absolutely. So I think the first thing to say is, no, we're not all clear, and the state is certainly not all clear on this either. So if you read the Expropriation Act, you'll find that it doesn't say that we're talking about the property, land, and assets that the whites accumulated during colonialism and apartheid crimes against humanity. Those words appear nowhere in the law, and they will never appear anywhere in the law, because the second that happens, South Africa becomes a pariah state akin to North Korea and so forth, or Venezuela. So that's simply not going to happen. You're not going to have this kind of Nazi-esque kind of retribution of collective punishment. It's not going to happen in South Africa, and I'm sorry to tell you that. But the key thing again is that restitution is imperative. There can be no kind of debate on the imperative of restitution. If you can prove that your property or property that was owned by your ancestors in title was taken kind of illegitimately for racial reasons or for political reasons, then you are by right entitled to reclaim that property. But what NDZ Meat, I think, is alluding to here is more in the vein of the EFF and MK and the old party Black First, Land First, is this idea that there's this kind of original sin, this stain of injustice that will always taint people by virtue of this color, the color of their skin. That is incompatible with a free society that prospers. So you can do this. You can do this and chase the whites into the sea or whatever. You can do all of this, and it has been done before. It has always failed. There is not one singular example of a society becoming prosperous on the back of this approach. But we have many other examples of societies with histories of injustice, and there are very few societies in the world that don't have a history of injustice, specifically injustice linked to private property. Those societies that came out of that period and thrived did so by respecting people's property rights, respecting people's freedom, respecting the principle that the state is not a tool that we can use to bludgeon our kind of political opponents or kind of settle scores between collective groups. The state is a guarantor of public order. That is what it must be. It is precisely because the state stepped out of that framework during colonialism and during apartheid that we are in this mess that we are today. And to propose that we must double down and kind of carry on that's just inviting more suffering. I think South Africans have suffered enough. The recipe for prosperity is there. There's nothing that makes poverty necessarily endemic to South Africa. We know how to end poverty, and one of those things, very simply, is to respect people's private property, and as the Constitution says, to expand private property ownership to as many people as we possibly can, especially amongst the ranks of the poor.
No, absolutely. And there's a comment here from Newsflash with Joe Emilio. How does the Free Market Foundation plan to protect private property rights? And are you in the process of fighting it legally? Yes, we are going to be launching litigation against the Act. I should also mention the Free Market Foundation's Kaya Lam project, which I think is really important as a corrective against some of this rhetoric, this hostility towards private property rights. Secure titling is something we're very passionate about. We don't just believe in this as an idea, but I would invite you to check out the Kaya Lam website, kayalam.org.za, and you'll see here that we are proudly boasting that we have almost achieved a significant milestone of transferring 20,000 title deeds to worthy beneficiaries. We assist with this process. We work with conveyancers and donors who provide financing for the project, and we also work very closely with municipalities and to assist them with the capacity that they need to transfer titles from the municipalities to the former residents, former renters of council rental stock, tenants, who now become the legitimate and rightful owners of those properties. So yeah, please do check that out. And I think that's very important, because now you have skin in the game as somebody with a title deed. Not only can you transfer that asset to your children or use that as a mechanism for obtaining debt financing, for example, or collateral, use it as collateral for starting a business, but it's also a recognition of your fundamental rights as a human being of ownership. And I think that's what something like Kaya Lam does so effectively. And Martin, there's another comment here by Ayanda Zulu, who's actually an associate of the Free Market Foundation, and he makes a good point here about the principle of solatium. Could you expand on that idea? So there's not just market compensation, but actually compensating you for the loss and the inconvenience that you've incurred.
Yes, absolutely. Thanks, Ayanda, for prompting me on that. This is a key thing, and this is an old principle that recognizes the involuntariness of expropriation. So remember, expropriation is not a tool for punishment. It is a thing that the government, as a last resort, really, is allowed to do to pursue social improvement. So the kind of classic example is a bridge needs to be built over a ravine. That ravine is in someone's private land. There's a pressing economic necessity to build the bridge. The owner of the ravine's land didn't do anything wrong. He's not at fault for owning the property. But now the state says, sorry, we have to do this. Here's compensation for that piece of your land that we're expropriating, and just to say sorry that we're dragging you into this because you weren't selling that property. So just paying you market value isn't sufficient because you didn't want to sell it in the first place. Like if someone gives you market value for your house, it's like, well, thanks, but I kind of enjoyed living there. I didn't want to sell it. Solatium is the extra amount to say, we recognize that we as the government are pulling you into a situation here that is not of your own making. And we apologize for that. And here's the extra money. So one of our recommendations is that there must always be a payment of solatium from a set minimum in a new Expropriation Control Act, which kind of that minimum could be anything, but we've proposed 50,000 Rand, or alternatively, if above that, 5% of market value of the property. And this is necessary. It has to be, this isn't said enough. It has to be expensive and costly for the state to expropriate. You cannot make it easy and kind of frictionless for the state to expropriate, because then you're inviting a reversal of the relationship of citizen and civil servant. In kind of democratic theory and constitutional theory, citizens sit above the government, believe it or not, and they're supposed to serve us. But if our servants can just take our property without that coming at a massive cost to them, then that relationship is no longer kind of in that way. Then we certainly are the serfs and the plebs that serve this political elite, and that is unacceptable. So latium is an important part of expropriation law, and one of the problems of the Expropriation Act, and one of the reasons we've said that it is reconceptualizing expropriation law into a tool of punishment, is that it removed solatium from the old Expropriation Act of 1975. Now, the old solatium provision was very limited. It was very low amounts of money, but still the principle was there, and it's been completely excised and removed from the current act, and that is unacceptable. That is completely unacceptable, because it amounts to the state saying, we do not recognize that we are doing something wrong to blameless, innocent property owners when we take their property. That is a problem. The state must always understand very firmly that when it chooses to expropriate property for any reason, the person it is targeting did not do anything wrong, and it is involving them in something, not of their own making. It has to happen. The expropriation has to happen. There is a reason that it's happening. But the person being expropriated must be made right by being compensated market value, and must be apologized to by being paid solatium.
All right, Martin, do we have time for one last question here? I think quite an interesting one, quite a challenging one. Given the custodianship form of property ownership, which was prevalent in some parts of the country, is a traditional authority through a monarch allowed to claim in your model of land reform? I think you also mentioned how kind of custodial land should be dealt with. Maybe you want to revisit that point?
Yeah, I mean, look, this is tough. This is a difficult question, and I'm not going to pretend to be able to kind of give a completely correct answer here. The reality is that traditional authorities effectively stood in the position of the state during colonial times. So obviously they were state owners of land in a sense, but that was only in some kind of sense, because it wasn't the Westphalian state, the Western state as we know it today. It was a different thing, and our argument is that these community formations should be seen as essentially voluntary, and that they should be seen as private. Kind of private interest groups and associations, and that doesn't detract from kind of any traditional authority that a tribal kind of monarch would have. That could all still be completely voluntary and still be completely enforceable on their property. So there's nothing to detract from that. Whether they can claim restitution of property, that's a very tough one. That's a very tough one. I think if they can prove kind of that after 1913, which would be very rare for them to be able to prove this, because most traditional authorities were kind of made into state, even during the apartheid years, they were made into state apparatus. They were civil servants when their kind of property was dispossessed during colonial times already. So it'll be very difficult in the restitution process after 1913 to prove that there was a dispossession, but it could happen. And again, it would be the onus of proof would fall on that monarch to go to court to say, this was my land as the traditional monarch in this area, and the Department of Bantu Affairs or whatever came in and said that we all have to move now and go somewhere else, and here's the evidence for that. And then our courts would absolutely accept that if it's proven, and you as the claimant would probably be the beneficiary of that. And then you should steward that asset to the benefit of your community. I think the Royal Bafokeng have done some interesting things on their part to steward communal property to the benefit of the community, rather than just kind of being part of the big state rent-seeking machine. So that is the type of thing that would have to happen. But usually in the claims process, it's going to be an individual or a family who can prove that they had a house in Alexandria, for instance, and this was dispossessed by the state when the black spot there was being removed, and they were being pushed back into their reserves and so forth. So yeah, in principle, I don't think we necessarily have an issue with a traditional monarch claiming property that he or she can prove was in fact theirs. But it is complicated. It is complicated. I don't think we should overcomplicate it too much in our own minds. So I think the principle is this: the state must remove itself from any conception of communal property. And if that kind of means that sometimes you'll have a monarch owning a huge tract of land that's the size of a municipality, okay, that's fine. We accept it. As long as the property is private, then something that kind of, I don't want to get too technical, but there's something known as the Coase theorem in economic theory. And that basically says that any property that is properly private will ultimately end up in the hands in which it is most efficiently and most desirably utilized to the benefit of society. So even if you think, oh my goodness, this huge land claim, whatever will we do? That is only a problem if it's state land. Then it's a crisis. But if it's really private, you'll sooner rather than later see that market forces are being brought to bear on that property, and that it will probably be subdivided, and people will acquire some kind of individual ownership in that area.
Right, Martin. Well, thank you very much for this session. I thought some of these questions were very interesting and engaging. So thank you also to our audience, and we'd invite you to, first of all, obviously read the report. You're welcome to follow up with us if you're watching this after the briefing has gone live. We'd be happy to answer any questions. But I'd also encourage our audience just to check out some of our other policy recommendations as well. That's at libertyfirst.co.za, and you can really sink your teeth into some of those recommendations. But that's it from us at the Free Market Foundation. This is one of many contributions to our very important objective, which is protecting and preserving private property rights in South Africa. And we've been doing that for 50 years now, and we intend to do that for very much longer. All right. Thank you very much to everyone for joining us, and remember, stay free.